Hello, everyone. This is Derek Teeter. I'm a partner in Husch Blackwell's Higher Education Group. Thank you for joining us at today's webinar on the law of religious liberty in higher education. Before we begin, just a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight just a few of those for you. If you have any questions during the webcast, please submit your question via the question box. We are monitoring that, and we'll try our best to answer questions throughout the webcast. But if a fuller answer is required, we may follow up with you via email after the webinar is over. We appreciate audience participation and encourage you to submit questions. A PDF of the presentation materials is available in the Resources folder. This program is pending approval for CLE, Continuing Legal Education Credit. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs and appreciate everything you share. That's all for the housekeeping items, so let's go ahead and do introductions and get started with our program. I've told you I'm Derek Teeter, one of the partners in the Higher Education Group, and my co-presenter today is one of our associates, Mackenzie Conway. Mackenzie is also a former teacher who understands the demands of education clients, having worked in the industry. Prior to joining the firm, Mackenzie taught students of diverse abilities and backgrounds at a public charter school in Kansas City and also served as a Teach for America Corps member. So we're excited to hear from Mackenzie today. We're going to tag team the presentation. You'll hear from me first and then from Mackenzie, and now I'll close out. So with that, let's go ahead and look at our agenda for today. We have quite a bit to cover, really three portions to this webcast. The first is talking about what we call constitutional religious liberty, and this would be the religious liberty rights that are embodied in the U.S. Constitution itself. We'll next talk about some state laws called Religious Freedom Restoration Acts, or RFRAs, which are a state law attempt to further protect certain religious freedom interests. And then we'll close with a discussion of some employment laws, Title VII and state counterparts, that regulate religious discrimination and religious accommodation in the workplace specifically. Okay, so let's start with a discussion of constitutional religious liberty. Now, this could take probably a month's worth of course time in a law school, so we're covering a lot today, and it's just really a smattering of what you really could dive into this on. But the First Amendment to the U.S. Constitution not only has protections for freedom of speech, which many people are familiar with, but it has two important religion clauses. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So we have what's called the Establishment Clause and the Free Exercise Clause, and we're going to talk about both of those. The First Amendment and these clauses are a restriction on the ability of the federal government as well as state governments with respect to either establishing religion or inhibiting an individual person's exercise of religion. So they apply to public entities, state universities, community colleges, state-funded technical schools. They don't apply to private institutions, although many private colleges and universities may adopt similar principles through their student or employee handbooks. Some of the laws we'll talk about in the employment context will specifically apply to private entities. Okay, so let's look at the Establishment Clause first. And the question is, what does it mean that the state, that is the government, can't establish a religion? There's sort of four key parts to this provision of the Constitution. First, government actions cannot have the principal or the primary purpose of either advancing or inhibiting religion. In addition, the government has to avoid actions that would create excessive entanglement with religion. There are certain limitations on the government's ability to sponsor religious symbols and religious prayer, with certain narrow exceptions. And then the final principle is that religious entities can benefit from state action as long as it's a religiously neutral government program. And we're going to look at some examples that will illustrate all of these different concepts in the higher education setting. So let's go ahead and do that with our first example. And I'm going to follow this up with a poll question, so pay attention. You'll have a chance to give your thoughts on sort of how this example shakes out. Suppose we have a state university that wishes to establish and run a divinity school to prepare ministers for a particular religious denomination to the exclusion of other denominations. The divinity school would be supported by state funds and tuition charged by the university. Okay, so I'm going to ask you a poll question now. Can the state university establish the divinity school? You should see that poll question on your screen, and you should be able to select yes or no. Give you just a moment to do that. Okay, so with a large portion of you having responded, let's see the results. About 85% of you say no, a state university cannot establish a divinity school, and that is the correct answer. So thinking back to the principles of the Establishment Clause, a state university can't do something the primary purpose of which is to enhance or support religion, and that's sort of the purpose of a divinity school. I also think we would have excessive entanglement because this is a divinity school that was specific to a particular denomination, which would require the state to make sort of doctrinal choices about what is orthodox or what isn't orthodox, and that would be a problem too. Okay, what about this example? The dean of a business school at a public university insists on beginning each faculty meeting with a spiritual invocation, rotating amongst different religious viewpoints. And the dean requires all faculty to attend and to stand and be silent while that prayer or invocation is said. So it's not specific. Maybe it's a Christian prayer one day, a reading from the Torah the next, but it is religious in nature. So the poll question to you, does this violate the Establishment Clause? And give you all just a moment to select an answer, and then we'll share the results. Okay, so with the lion's share having responded, let's see what you think. Does this violate the Establishment Clause? About 70% of you say yes. About a third of you say no. I think yes is the best answer here. Generally speaking, the government cannot sponsor prayer that people are required to sort of sit through. There are certain exceptions. The courts have said that when an invocation is part of the historic practice, like an invocation at the beginning of Congress, then that can be okay. However, I don't think prayer or invocations at the beginning of a department meeting are sort of rooted in the history and tradition of the nation, and so probably that would be a violation of the Establishment Clause. Remember, that was a spiritual invocation. It wasn't a moment of silence, and so that's a distinction that matters in this space. Okay, our next example. A religious student group seeks to be recognized by a public university so it can access funding opportunities paid for by student fees. The university allows all other kinds of student groups to register, but bans the registration of religious groups. Okay, so the poll question for you: is the university's ban permissible? Give you all just a moment to answer that. Okay, and so with most of you having responded, about 85% of you say no, you couldn't do this. You could not ban a religiously affiliated student group from accessing the funding through registration. And that is the correct answer. So how do we get there in terms of the Establishment Clause principles? One of those principles was religion can benefit from a neutral program and shouldn't be excluded on the basis that it is religious. And so if we have a system where all sorts of registered student groups of all different types can access funding, then a religiously affiliated student group should be able to access it as well. And that is not the state improperly supporting religion. It's just allowing religion to participate on equal terms with secular groups. Okay, what if a state university allows community groups of all kinds to rent space in its conference center for a range of different events, including political events and philosophy symposia, but the university refuses to rent to any group that seeks to hold a religious event in the conference center? So the prohibition is on any religious event. It's not specific to a denomination. What do you think? Can the university refuse to rent to groups seeking to hold religious events? And again, just waiting for enough of you to respond that we get a good sense of the group. And let's see what you thought about this one. Can the university refuse to rent to groups that seek to hold religious events? Most of you, an overwhelming majority of you, say no. And again, that's the right answer because this was a government-neutral program that was really open to any sort of group, including secular groups focused on philosophy and other topics that are sort of similar to religion. But religious groups were excluded based on their status as religious. And so that would be problematic, actually, from a First Amendment perspective. Okay, let's do one more of these before we transition into some discussion of free exercise. Let's suppose a public university allows only recognized student groups to use space in its union, and an outside religious group seeks to use space in the student union, but is denied access because it is not a recognized student group. So, what do you think of that example? Can the university deny the outside religious group access to the space? And while we're waiting, a couple of folks have asked about the very first example. Essentially, does it matter if it's an invocation at the start of the department meeting as opposed to a moment of silence? Well, if it's an invocation, it almost certainly is going to violate the Establishment Clause. If it's a moment of silence, it might not. It depends upon what the purpose of the moment of silence is. If the purpose of the moment of silence is to give people a chance to orientate themselves and think about what the meeting's going to be about or do whatever they want, it might pass muster. If it's a de facto form of forcing everybody to pray, then it might not. So there's some factual questions that are sort of bound up in that scenario. But the invocation at the beginning is sort of very clearly going to be a problem, at least at a department meeting where people are forced to sit through it. Okay, so what do you think about this question? Can the university deny the outside religious group access to the space? 95% of you say yes, it can. Okay, so why? What's different about this example? So the rule here was you have to be a registered student group to use the space. That is a religiously neutral rule, registered religious groups could use the space. But the university can reserve its property for itself or for those groups that are part of its community. It doesn't have to open them up to the outside. And so this distinction, this limitation would be permissible under the Establishment Clause. Okay, so let's transition now to a discussion of the Free Exercise Clause, and I'm going to hand it off to Mackenzie to do that.
Thank you, Derek. So as Derek mentioned at the beginning of this webinar, the First Amendment has two clauses that address religion, the Establishment Clause and the Free Exercise Clause. So what does the Free Exercise Clause protect? The government cannot take actions that specifically target free exercise unless they satisfy a standard called strict scrutiny. So with strict scrutiny, the government would have to show that they have a compelling government interest, as well as that this action is the least restricting means of satisfying this compelling interest. The government can take neutral action that only incidentally burdens religion, as long as there is a rational basis for the action. A rational basis is a relatively low bar that just means whether the government actions are rationally related to a legitimate government interest. And if the government makes any exceptions for non-religious actions, the government also needs to make exceptions for religious actions of a comparable nature. Currently, in front of the Supreme Court is a case that really hits on the points of the Free Exercise Clause. And although this is more of a K-12 case, there are far-reaching implications depending on which way the court decides for higher education. So it's Carson v. Macon, and it is a challenge to a Maine program that pays for some students to attend private schools. There's a system that the state uses to make sure that children have the opportunity to receive a free public education, because not all school districts in the state have their own secondary schools. So, for example, some districts make arrangements with specific private schools or public schools in other districts for their students to attend those schools. And other school districts allow their students to choose whether they want to go to the public or private school, and they pay their tuition. Maine only allows these tuition payments to go to private schools that are non-sectarian. So they cannot go to private religious schools and receive this tuition assistance from the state. So two families who live in a district that does not have their own secondary schools and are otherwise eligible for this tuition assistance want to send their kids to religious private schools. And they were denied. So they argue that the state not allowing schools that provide religious instruction in the program violates the Constitution. The Supreme Court heard oral arguments in December after the First Circuit ruled in favor of the state. So, two sides of the argument. The parents argue that excluding sectarian options violates the Constitution because it's not neutral toward religion and it's not generally applicable. So the program only allows private schools to participate in tuition assistance if they are non-sectarian, and then state officials, they allege, have to make a judgment call on essentially how religious a school is. On the other hand, the state argues that public education should be non-sectarian and expose children to diverse viewpoints. Specifically, the state argued that the schools that these parents were considering only hire Christian teachers, for example, or refuse to admit LGBTQ plus students, saying that this is not furthering this interest of exposure to diverse viewpoints. The state also argues that the families are not being denied a generally applicable public benefit because the benefit is a free public education, not a private religious education. So we're not quite sure how the Supreme Court will come out on this, but a decision is expected sometime this spring, so that's definitely something to keep an eye out to see what implications might arise for higher education, depending on which way the Supreme Court goes. And we are going to get into some examples now, going off of the free exercise clause. So in this first example, a public community college adopts a rule prohibiting proselytizing anywhere on campus. The college allows all other manner of speech on campus, including politicking and petition drives. The rule prohibiting proselytizing is not subject to strict scrutiny and therefore constitutional. So is this true or false? The rule prohibiting proselytizing is not subject to strict scrutiny and therefore constitutional. We'll give you a couple of seconds to answer. Okay. Looking like over 90% of you said false. False is the correct answer. Here, the school prohibits people from attempting to convert someone from one religion or belief to another, but they allow, for example, attempting to convert someone from one political party to another. So we can see this as specifically targeting religion, and therefore it would be subject to strict scrutiny. Presumably, what the school is concerned about is a student cornering another student and harassing them or threatening them. So this rule is overbroad. It's not just addressing harassing behavior, it's addressing any behavior attempting to convert someone to a different religion. The rule would have to be changed, maybe to say that you cannot come up to someone and speak in a commercial way when you're in a classroom, so that it's not specifically targeting religion. Also, this rule would not be the least restrictive means. It said anywhere on campus is where it's banned, and it's, again, overbroad. Public universities' code of conduct bans smoking of any kind on campus. Religious student wishes to smoke peyote on campus as part of a religious ceremony. So, is the code of conduct religion neutral? Is our first question. We have a couple of seconds for everyone to get their answers in. Okay, so the code of conduct is religiously neutral. It prohibits smoking anywhere on campus. That's what the code of conduct says. religion is not mentioned in the code of conduct, so it is neutral. The follow-up question is, will the code of conduct survive a rational basis review? So since we've established that it's religion neutral, that means that it is subject to rational basis. Will it survive? We have a couple of seconds to answer that question. Looking like we have a good amount of you that have answered. So will this survive? 92% of you say yes, this would survive rational basis. Many colleges and universities do have smoking bans. Remember, rational basis, there has to be a rational relationship between the action and the government interest. Protecting the health and safety of the campus community by prohibiting smoking on campus is a legitimate government interest, and banning smoking is rationally related to achieving the interest of promoting the health and safety of the campus community. So that would survive. Okay, private college bans religious gatherings on campus to limit the spread of COVID, but the college allows a range of other gatherings, including political meetings, movies, and dances. Does the college's ban violate the free exercise clause? Go ahead and submit those answers. All right, let's see. Oh, I'm seeing that our trick question here might have caught a few of us. So, does the college's ban violate the free exercise clause? Actually, the answer is no, which 30% of you got, and I hope that you got that because you notice it's a private college. So it's a private college, which is not subject to the free exercise clause. The private college could do this unless they had a policy or there was state law that said otherwise. But the private college is not implicated by the free exercise clause. But what if the college was a community college? Community college wanted to proffer the same rule. Would this violate the free exercise clause? Go ahead and submit those answers. Yes, didn't trick you there. This would violate the free exercise clause. The community college does have to adhere to the free exercise clause. Here, this rule specifically targets religion. There are non-religious exceptions, such as dances, concerts. So there would need to be religious exceptions as well for comparable actions, which religious gatherings would be. So this would violate the free exercise clause and would not be constitutional. Okay, that brings us to the end of our free exercise discussion today, and we are going to transition to looking at state law, specifically looking into what are state RFRAs. A RFRA stands for Religious Freedom Restoration Act, and many states have enacted RFRAs in response to the Supreme Court's decision in the 90s in Employment Division versus Smith. So prior to Smith, strict scrutiny applied to any governmental action that applied to religion, whether it was neutral or whether it targeted religion. Smith changed that and applies what we have now, which is a rational basis review to religion-neutral actions that only incidentally burden religion. So the states enacted RFRAs to go back to this original framework, and typically a state RFRA will prohibit state agencies, including universities, from substantially burdening the exercise of religion without meeting strict scrutiny. That was the goal of the RFRAs. And again, strict scrutiny, as we mentioned before, to substantially burden the free exercise of religion, the governmental entity must show there is a compelling governmental interest, and that burdening the free exercise of religion is the least restrictive means of furthering the compelling interest. Let's dive into a couple of examples, and for these next few examples, we're going to assume that the state in which the school is located has a RFRA. So that means that it would be subject to strict scrutiny. So keep that in mind as we're going through the examples. Okay. State University has a compelling interest in prohibiting the slaughter of animals in residence halls based on health and sanitary concerns. The prohibition substantially burdens religious practices of students who wish to engage in ritual slaughter of animals in residence halls in accordance with their religious beliefs. The university can demonstrate that prohibiting the slaughter in the residence hall is the least restrictive means of furthering this health and sanitary interest. So has the university passed strict scrutiny? We have a couple more seconds to get those last responses in. The university has passed strict scrutiny, which I see 92% of us said as well. We're assuming the state has a RFRA. They need to pass strict scrutiny. In the facts, the university can show that it is the least restrictive means. Doesn't matter if it's religiously motivated or not. It's no animal slaughter in residence halls. Kind of the opposite of this can be seen through some case law. There's a case in Florida, the Leukemia versus City of Halle case, where the city council had ordinances that said there was a prohibition on possessing animals for sacrifice or slaughter. And the city ordinance carved out exceptions for state licensed activities. So the difference in that case is that the ordinance prohibited ritual animal sacrifices, did not meet strict scrutiny. It needed to be justified by a compelling governmental interest and narrowly tailored. The core failure there was that the ordinance applied exclusively to this one church that was proffering the animal sacrifices. So great job on that question. Next question. State University has a compelling interest in not having loud noises in a residence hall after 9 p.m. to allow students to sleep. To achieve this interest, the university prohibits all music in a residence hall after 9 p.m. This rule burdens the religious practice of a student whose belief includes sung nightly prayer at 10 p.m. Does this prohibition meet strict scrutiny? So there needs to be a compelling governmental interest, and it needs to be narrowly tailored to achieve this interest. Alrighty, looks like we are all answered. Does this prohibition meet strict scrutiny? Ooh, this is an interesting one, seeing we're pretty split, almost 50-50 here. So this does not meet strict scrutiny. We need a compelling interest. You would say there's probably a compelling interest in restricting loud noise. Probably couldn't say no one can speak, no one can talk, but having a compelling interest in people trying to get sleep at night. If there was a general rule saying no loud noises or no loud music, that would probably survive. So even if the music was prayer, the student would not be able to engage in this loud music or a loud prayer. But it's not the least restrictive means of achieving this interest in restricting loud noise, because it's all music, even if sung quietly so that no one else could hear it, is prohibited. The regulation would need to be more narrowly tailored in this case. That was a good one. So how are these state RFRAs enforced? Usually they're enforced by private lawsuits that seek injunctive relief, damages, attorney's fees, and costs. Sovereign immunity is not a bar, and they may also be asserted as a defense to a judicial or administrative suit against an affected person. And in some states, the state attorney generals may have the authority to enforce this. And that covers our state RFRAs. I'm going to turn it back over to Derek to go through Title VII and some non-discrimination laws.
Okay, thanks, Mackenzie. And I see we have a number of questions. I think we'll have some time at the end to cover most of those. But I want to make sure we get this last piece of content. So Title VII and non-discrimination laws, state counterparts. These are civil rights laws that protect religious liberty, specifically in the context of the workplace, is what we're looking at. Title VII is a federal law that prohibits employment discrimination based on a number of protected statuses, race and religion being two of the primary ones. Title VII does have an exemption for religious institutions themselves, which can have a preference for employees of their own religion. But otherwise, Title VII is going to require both public and private secular employers not to discriminate against persons based on religion, and also to provide certain accommodations for persons who are employees and need an accommodation for religious practice. Most states have a state law counterpart that will mirror Title VII, or at least be very close to it. The Missouri Human Rights Act, the Kansas Act Against Discrimination, these are examples. So these laws, they do two things. First, they prohibit what you might call classic adverse treatment discrimination, treating an employee adversely with respect to the terms and conditions of their employment and where religion is the motivating factor in the treatment. The law says you generally can't do this. It's unlawful discrimination. And so how might that potentially present itself? Suppose a supervisor at a private secular university disagrees with a subordinate employee's religious beliefs, which the supervisor views as heretical. And because of this disagreement, the supervisor cuts the employee's hours and fails to give the employee a raise, despite giving them to similarly situated employees whose religious views happen to align with the supervisor's. So that's our scenario. Can the supervisor cut the employee's hours in this way? What do you think? Give you just a moment to respond. Okay, so looks like we have fairly good responses, and 95% of you say no, you can't do this, and that's the right answer. The motivation to cut the hours is disagreement with the subordinate's religious views, which is religious discrimination. Title VII and the state law counterparts would say you can't do that. What about this example? Let's say we have a Muslim employee at a public university who faces repeated joking and denigration from coworkers about the employee's faith. And the employee complains to their supervisor, but the supervisor fails to act. And so the employee develops anxiety and dreads coming to work as a result of this joking and denigration that's going on. So the poll question is, could the employee bring a hostile environment claim under Title VII against the employer? What do you think? Okay, so with quite a few of you having answered, about 98% of you say yes, the employee could bring a hostile environment claim, and that's correct. So another form of adverse treatment discrimination is failing to remedy the harassing misconduct of colleagues. And in this example, we had religious-based harassment from colleagues, and the institution was aware of it and did nothing to prevent it, and so we had a de facto form of religious discrimination in that example. So that's sort of adverse treatment discrimination, intentionally harming someone because of their religion or allowing a religiously hostile environment to be perpetuated and not stopping it. Those are both violations of Title VII and these counterpart state laws. These laws also, however, require employers to make certain accommodations for employees who have a religious need, unless granting that accommodation would impose an undue hardship on the institution. And so this is conceptually different than not engaging in adverse treatment discrimination. This is affirmatively accommodating an employee from some baseline rule or expectation of the employer. Okay, so there's two really important concepts baked into this slide. The idea of a sincerely held religious belief, and then the idea that the accommodation can't impose an undue hardship. So let's unpack both of those. What does it mean to have a sincerely held religious belief? The question is whether the employee as an individual has a personal, genuinely held belief. The belief does not have to be part of an organized religious structure. The belief does not have to be orthodox to the employee's claimed faith. And the religious belief can still be sincere even if it is recently adopted, and even if sometimes, occasionally, the employee acts in a manner inconsistent with it. The religious belief does not have to be validated by a religious leader in order to be genuine. An employee might choose to have it validated to substantiate it, but it doesn't have to be genuine under Title VII. So let's look at a couple of examples where we're dealing with this, right now and for the last 18 months. COVID-19 vaccines and other COVID-19 mitigation mandates. You probably have gotten these accommodation requests at your institution. Employees who say they have an issue taking the vaccine or an issue covering their face, and it's rooted in a religious belief. And the guidance from the federal EEOC that enforces Title VII says you have to treat these requests the same way you do other requests. You should assume that if someone is saying they have a religious objection to a COVID-19 vaccination requirement, then that can be a sincerely held religious belief. And you can make a very limited factual inquiry into that, but you shouldn't require the employee to substantiate this religious belief in a way that's different from how you generally operate. And then the question becomes, in light of that belief, would it create an undue burden for you to grant the accommodation? And we'll look at some examples in just a slide. Now, we make this point because there are some states, and Kansas is an example, and there are others, at least that have pending legislation, that have explicitly forbid employers from inquiring into the sincerity of religious beliefs as a basis for a claim of a COVID-19 accommodation from vaccine requirements. So this is an area where you have to be especially careful not to go beyond the very limited inquiry the law allows in terms of the sincerity of religious beliefs, which basically is just asking an employee to articulate what their belief is and that it's genuine. So once you have, though, that sort of genuine religious belief, and that triggers the inquiry about whether you get into incurring an undue burden or not to grant the accommodation. So let's start to look at that in some examples. A self-described Catholic employee professes a belief that any vaccine derived in any way from fetal stem cells is inherently immoral and cannot be used regardless of its social benefit. However, the Pope has issued guidance that certain vaccines are permissible if their connection to fetal stem cells is remote. So that's the factual scenario we have. Is this a genuinely held belief from the employee? And you can pick yes, no, or it depends. So I'll give you all just a moment to do that. And with quite a few of you having picked an answer, about 60% of you say yes. And that's probably the best answer. Remember, a sincerely held religious belief does not have to necessarily be orthodox to a particular religion in order to be sincerely held. And so even though the Pope, as the head of the Catholic Church, is teaching one thing, it's possible that someone as a self-described Catholic could hold a different sincerely held belief. Now, those of you who picked it depends might be saying, well, maybe the belief is not actually genuine. Maybe it's sort of been manufactured because this employee doesn't want to take a COVID vaccine, but they've taken all sorts of other vaccines that are derived from fetal stem cells. And if that was true, that might be a basis then to question the bona fides of it, but not because it's inconsistent with the teachings of the Pope. What about this example? An employee who previously self-described as a Christian reports they have converted to Islam and now seek a scheduling change to allow the employee time off on Friday for prayer. Is the employee who has only been Muslim for a few days expressing a sincere belief? Yes, no, or it depends. Okay, so with a number of you having responded, I think probably a pretty good sense of the audience. 84% of you say yes, no one said no, and a few said it depends. So remember from the first slide, a religious belief can be one that was recently acquired, and people do convert faiths, and that conversion is effective on the moment it happens for purpose of sincerity of religious belief. So unless there was some reason to think this was all fake to just get out of some particular Friday, this is almost certainly a genuine belief, and you would have to run the analysis of whether it's an undue burden to grant the accommodation. A university's application for a religious accommodation requires employees to list the name of a religious leader who can attest to the sincerity of the employee's religious belief. An employee indicates their religion does not have a hierarchy and all adherents are equal. And the poll question is, can the institution deny the employee's accommodation request? So the form says you have to give us the name of a religious leader, and this employee says, my religion doesn't have leaders. We don't even believe in that. We're all equal. Okay, and so with quite a few of you having responded, almost 98% of you say no, you can't do this, and that's the correct answer. You could provide a space where an employee might choose to identify the name of a religious leader, but you can't require it, because a person can have a sincerely held religious belief without having to have that validated by someone else. And some religions don't have leaders. Some religions actually have beliefs like this one that says there really is no hierarchy. Okay, what if an employee submits a request for religious exemption claiming the employee wants to be exempt from a COVID-19 vaccine because the vaccine has not been thoroughly tested, the employee does not trust the FDA, and the government is, quote, running people's lives, close quote? Has the employee shown a sincerely held religious belief? Yes, no, or it depends. Okay, so I'll give you all just a moment to answer that one. And about 97% of you say no, that's not a sincerely held religious belief. And so what's different about that example? It looks on its face like it's a political belief, not a religious belief. And the case law says for something to be a religious belief, it's got to be rooted in a sense of the divine or a philosophical ordering or the nature of reality. But disagreeing with what the government's doing isn't synonymous with a religious belief. So I think probably on these facts, that's sort of a political belief being characterized incorrectly as religious. Now, where that line is in a given situation can be difficult to discern. And in some cases, people may have a religious belief that coincides with a religious belief and has a religious ground. So you do have to be cautious. Okay, so if we have a sincerely held religious belief, we have to grant an accommodation unless it creates an undue hardship. So what does that mean? For a hardship to be undue, it has to be genuine. It can't be speculative. The burden has to be more than de minimis. So maybe it's costly, it compromises safety, infringes the rights of others, violates collective bargaining agreements, makes other people do more than their fair share of hazardous or burdensome work. A university bookstore manager prohibits employees from wearing hats because it looks, quote, unprofessional, but a Jewish employee wishes to wear a yarmulke, which the manager considers a hat. Does the manager need to accommodate the Jewish employee? Give you just a moment to answer that. Okay, so with a number of you having responded, almost all of you say yes, and I think that's the right answer. It's not likely to be viewed as unprofessional for a Jewish employee to wear a yarmulke. It's not disruptive. It's not going to be an undue burden to accommodate this. And the EEOC has essentially said this is the expectation, unless there's actually a safety reason not to wear a head covering. An employee normally works on Fridays from 7 to 5:30. The employee wishes to schedule time off to attend Good Friday service and gives several weeks' notice of the request. Does the institution need to accommodate this schedule change? Okay, give you all just a moment more. I think this one's pretty straightforward. And so almost all of you have said yes. And that's the correct answer. You accommodate schedule changes for other reasons, health, weddings, funerals. You would need to accommodate it based on the need to go to a religious service. An employee works in the cafeteria at a public university. The employee professes a religious belief against wearing any kind of covering on his hands or his head, but local health code says food service workers have to wear gloves and hairnets, and 70% of this employee's job duties include food preparation and service. Okay. Does the university have to accommodate this employee? What do you think? Okay. Give you just a moment more. And most of you say no, almost all of you say no. And so what's different? Well, we have to look at the job duties here. 70% of the job involves working with food where there's a legal obligation rooted in health and safety to wear gloves and some sort of hairnet to keep hair and debris out of the food. So it would be an undue burden to excuse the employee from that requirement because it's tantamount to saying you don't have to do 70% of your job, and that's an undue burden. A university employee who works in student healthcare facility treating sick students professes religious opposition to both the COVID-19 vaccine as well as face covering requirements of any sort. The institution has imposed a vaccine mandate with a face covering accommodation for those with a religious objection to the vaccine. Is it an undue hardship for the university to accommodate this employee? Okay, so giving you all a moment here. Okay, 81% of you say yes, that's an undue hardship. I think that's probably the right answer. So how do we get there? Well, we look at the nature of this position. It's in a healthcare setting, working with sick people. So we have a population who's going to be particularly vulnerable to a COVID-19 infection. We need to do something to mitigate the risk of transmission. And this employee not only wants an exemption from the primary mitigation tool, the vaccine, but also an exemption from the backup, that is wearing a mask. And so I think it would be a good argument for the university to say this just creates too much risk for sick patients for you not to be doing anything. And you won't even wear a face mask or a face shield. So no, we can't grant that accommodation. Now, if the person was someone who worked on a grounds crew mowing the grass, I'm not sure we would have the same outcome. A college employee professes a religious belief in constant evangelization. The employee seeks an accommodation from workplace restrictions that bar the employee from attempting to evangelize coworkers during working hours. And the coworkers object that such an accommodation would violate their right not to be subjected to evangelization at a government workplace. Okay, so the poll question, is accommodating the employee an undue hardship? This is our last example. And giving you all a chance to select an answer. 85% of you say yes, it's an undue hardship. How do you get there? I would say for two reasons. One, you have this question of, is it actually invading the rights of other persons? not to be proselytized at while they're working? Probably so. But second, the employee is being paid to do work while they're at the office, not to engage in private action through proselytizing. And so you don't have to accommodate someone in the sense that instead of doing their job, they can instead go around and proselytize on the institution's dime. In the same way, you could say to someone, yeah, you have a First Amendment right to say what you want on Twitter, but you can't take 2 hours out of your working day to say things on Twitter. That's not what we're paying you to do. Okay, so that's all the content. Let's just sneak in a couple of questions here because there's a bunch of them. Okay, would it be an undue burden if other employees need to do extra work following someone having days off for religion? Well, probably not if it's an occasional day. I mean, that happens at baseline, right? If you have a sick employee or someone who's going to be gone for a wedding, you might have to do a shift change. Maybe you ask someone to work an hour of overtime. Occasionally doing that's not going to create an undue burden because it's part and parcel of the normal flow of work. If someone needed every Friday off and you required one person to always work an additional Friday and therefore always have overtime, now maybe you're in a space where we do have an undue burden. Let's look at some other ones. May an employee use religious memorabilia to decorate their office where students will enter regularly at a public community college? Wow. So that's a complicated question because now you have the intersection of both the institution's obligation not to primarily support religion, but you also have the free exercise and First Amendment rights of the employee to say certain things. And the answer to this question really depends upon what sort of First Amendment expectations you've created for employees. Do you allow your faculty members to put personal effects up on the wall? And if so, can they put up whatever they want? If the answer is yes, you probably can't prohibit one from putting up religious pictures if everybody else can put up political pictures and travel pictures or otherwise. So some of it depends upon sort of what expectation you've set. I'm fairly confident that allowing an employee to have some religious memorabilia on their walls isn't going to violate the Establishment Clause unless you're sort of systematically forcing students to go in there and confront it in a way that's really onerous. Okay, let's do just one more, and then I think we're going to have to answer the rest of these by email. Okay, someone has said, actually two people have said, the Carson case that Mackenzie mentioned, do we have any thoughts on how the court's likely to rule there? This was the case involving the Maine sort of funding scheme, the state of Maine, that is, for state funds to be used at private schools, but not ones that are religious. I think the court is likely to declare that system unconstitutional. From the tone of the arguments and given the current court's composition, I think it will view that as a state program that is punishing religious institutions for being religious, and the state's attempt to say, well, we don't want the money being used for religious instruction. I don't think the court's going to view that as a valid distinction between religion and instruction because the nature of religious entities is to instruct. So that's just my sort of impression, that the court will probably declare that to be unconstitutional, which will mean, if I'm right, it's further support for this line of precedent that says if you're going to offer a public benefit, you can't sort of have targeted carve-outs for religious entities in most circumstances. Okay, let's go ahead and close. We're a little bit over time. Thank you for your questions and for joining us today. We hope the information was helpful. If you haven't done so already, please click on the survey link and give us your feedback. We do read it and we appreciate it. The program is pending approval for CLE. You can download the certificate of attendance from the certificate widget that is at the bottom of your screen. A recording of the webcast will be available tomorrow for watching and sharing. And once it's available, you'll get a link in your email. Please join us for our next monthly higher education webinar, which is on affirmative action in hiring. And that is scheduled for noon Central on March 22nd, so about a month from now. That concludes our webinar. And again, thank you for your attendance today.